Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Versus Scott Glenn Wright, file number 25-7300FH. This time of day sets for sentencing. The defendant is present, represented by Attorney Elizabeth Weisenbach. People are represented by Prosecuting Attorney Timothy J. Rakowski. By way of history, the defendant pled guilty to operating while intoxicated, third offense. That was on July 21st of this year. Mr. Nate Lake has prepared the pre-sentence report dated August 26th. Ms. Weisenbach, have you and your client had the opportunity to read the report?
Yeah.
Any additions, deletions, corrections, or objections to the report other than guidelines?
No.
Any objection to the guidelines?
No.
Do you agree with that, sir?
Yes, Your Honor.
Thank you. Mr. Rakowski, any objection to the report as well as guidelines?
No to either question, Your Honor.
Thank you. Ms. Weisenbach, what would you like to say on behalf of your client before the court imposes sentence?
Thank you, Your Honor. So my client comes before the court 58 years old with a bit of a record. It's a kind of a split between severe alcoholism issues and also some substance abuse issues, variety and mixed bag there. Obviously, there's other charges, other convictions, but the basis has always been either an alcohol situation or else a substance abuse situation. He has stated to you in his written to the court that I just can't seem to get the proper help to stay away from it, referring to alcoholism. My disease has cost me my freedom and many professions over the years, meaning that there were jobs and different licensing situations where he could have been employed, but for the fact that he had been compiling the list of alcoholism and or substance abuse issues. With that being said, I am a little shocked and appalled that the regional sobriety court refused him. And I understand, I don't know that everybody has this paperwork, but I do, and it indicates the two reasons. One, he's on parole. We know that the detainee is an issue, but that could resolve itself after this case does. So number one, I understand, but number two, I can't comprehend alcohol dependence is not a primary concern. So with that being said, he does have a recommendation from MDOC of 300 days with regards to sentence. And so that gives us time yet to apply to the recovery court outright, so that if they considered it more of a substance abuse issue, i.e. different types of drugs, then he could be qualified for that. We have that. We have 300 days. We have that time. That's the recommendation. Would ask the court to allow us to submit that. And if he does qualify and is in that program, then if he could be released from jail at whatever stage that this occurs, so he can start that program, it would be appreciated. Obviously, during the time that he has been sitting in jail, it has been time where he can recover from substances, alcohol, etc., and he would be clean and ready to get started. He's very anxious about that as well, so that he did indicate that. It was part of the prosecutor's agreement at the beginning with regards to accepting the plea. As you can see, it's sprinkled throughout this PSI that they have no objections with regards to him being in the sobriety court. So I'm at a square here because it doesn't make much sense. Why was he rejected from the program that everybody, including himself, when he self-reports, thought it would be a good program? So I understand this because of the detainee. Maybe that'll get resolved, and then it'll still have plenty of time, while he's in jail for 300 days, to be able to apply for the recovery court. So it asks the court to note this, consider this, and when we get to that point, I will keep this file, keep an eye on when the parole detainee gets resolved, depending on how that goes, and then apply him for the recovery court if that could be something that maybe they felt he was more in that direction, or if there's something else that he could consider. It's just, it's kind of a mystery. Alcohol dependence is not a primary concern. So I guess I'd appreciate it if they had just put a little star and said what they thought the concern was. I could go from there. So I don't have that mystery solved, but we can go from there. After talking to him, I kind of figured out it might be the pills and other higher, nastier drugs that he used. So anyway, ask the court to follow this recommendation and allow me to keep this filed to continue on to see what would be the next steps for him.
He was on parole at the time of this matter, correct? Out of this court?
Bay County.
Bay County.
Bay County.
Okay. Because he was before this court in 22, actually 23, served 275 days for possession of a controlled substance. And then in this court again in 20, jail sentence for resisting obstructing. Oh, I see, here's the Bay County. Yep, 33 and 37. Okay. Thank you. Did your client wish to address the court, Ms. Weisenbach?
Your Honor, I would hope that you would consider following the recommendation and that I would be given a chance in the recovery court. I was hoping I could get sobriety court, but if I do get recovery court, I promise I won't let you down. So,
Mr. Rutkowski, anything on behalf of the people?
Your Honor, being involved in one of the treatment courts, I've been there and I've seen that if there's a recommendation for TRRC and it seems like that person would be better suited for TRSC, the court would just send it over. I believe it would likewise be the same way because the same judge looking over that. We agreed that we had no objection if he was going to go to TRSC, but he was denied. So I think at this point now, we look at his record, I go back and he's got 11 prior felonies and 33 prior misdemeanors, if I'm not mistaken. And you look at some of these things, so back in 1990, one thing that jumped out at me, a UDAA, he absconded while he was on probation. And then in 2018, possession of cocaine, failed drug test, failed to report, bench warrant for his arrest on that case. He's on parole for this one, and it's a drunk driving case. Guidelines are 10 to 34. We would ask for the court to impose a prison sentence of 24 months.
Weisenbach,
Disagree. Thank you.
well, he's not eligible for TRSC. They determined he's not eligible for it. Frankly, I'm a bit surprised by it as well, but I don't make the call here. Clearly, it's a recommendation and the people recommended it and he was not accepted into the program. What is troubling is we have an individual who's on parole at the time out of Bay County. He's operating an ATV in Harbor Beach. And he was actually in treatment court in 2018 in Bay County. And obviously that did not work out because he was placed on a prison sentence then afterward. So at this point, it's been attempted and sadly it failed. It will be the sentence of this court to defendant be committed to the Michigan Corrections Commission, placed in the commission's custody in the state prison of Southern Michigan, to be incarcerated for a minimum term of 24 months to a maximum of 10 years. In addition to that, he is to pay state costs of $68. And I'm missing one here as well. State minimum fee. Well, correct. Private victim's right fee. What is that amount? 130. 130. That's all the court's imposing relative to fines and costs, but prison term the court is imposing. It's my duty to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, the court will assign counsel for your public expense. Please initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. No credit for time served in this case, as he was on parole at the time.
I'm assuming all sentences consecutive to parole.
Yes, under statute. That'll be off the record.